Good afternoon and welcome to the first webinar in our confidential information series. Before we start the webinar, we have a few small housekeeping points to go through. Firstly, to keep background noise down, you've been placed on mute. There will be an opportunity to ask questions at the end, but you can also use the chat function throughout the presentation today to post any questions that you might have, and we'll just pick them up at the end. This is the first webinar in our series focusing on confidential information and part of a wider series of webinars in the commercial litigation team. The next webinars in our series will focus on confidentiality in practice and preventing misuse of confidential information. Webinars from previous series are available if you follow the link on the screen, and following today's webinar you'll also be sent a recording. Your speakers today are Eloisa Crichton and me, Matt Phillip. I work in the commercial disputes team and regularly advise clients about confidential information in contracts, and Eloisa works in our employment team and has experience in dealing with confidentiality clauses when they arise in employment contracts and settlement agreements. In today's webinar, we are going to provide a general overview of the law relating to confidential information before going on to look at how to define confidential information, including trade secrets, and how to protect this information in a contract. The format of the webinar is shown on the screen. To start off, we'll take a more in-depth look at what confidential information actually is. We'll then hone in on trade secrets, one category of confidential information. Next, we will discuss some contracts where confidentiality clauses are particularly important, such as employment contracts, settlement agreements, NDAs and joint ventures. And we'll then go on to look at some common drafting issues which can arise when dealing with confidentiality clauses. We'll then end the webinar with some practical advice. The general principles discussed today are applicable in both Scotland and also in England and Wales unless we indicate otherwise, and that's because the underlying law is very similar in both jurisdictions. Now, the law of confidential information is used to protect information that falls outside the legal protection that's afforded to other intellectual property rights like patents or trademarks. In some ways, the law in this area is based on a simple moral standard that if someone has said they will keep a secret, then they should do so. To come within the definition of confidential information, the information must have what's called the necessary quality of confidence and also be disclosed in circumstances which show that there is an obligation of confidence. If this test is met, then the recipient of the information is not allowed to use it to the prejudice of the giver of the information without their consent. This includes disclosing it on an unauthorised basis to third parties, and the protection can arise even in circumstances where no confidentiality agreement is signed, but in practice it's often sensible to have some terms written down just to provide some clarity about what can and can't be done with the information received.
As Matt mentioned, there are two parts to the definition of confidential information. The first is that it has the necessary quality of confidence. This means that it cannot be public knowledge. In order for information based on public domain information to acquire the quality of confidence, someone must have added some thought and effort to existing public domain materials. For example, by adding a set of criteria for selecting a list of data or adding a description to the data items. More than just effort is required. For example, compiling a list of every address in a given area would take effort, but not be confidential as anyone could repeat it. Some examples of information which may be confidential include statistical information, customer lists, business plans, scientific discoveries, recipes which are not apparent from the end result, and financial information. One term often used in connection with confidential information is know-how, which describes practical information resulting from experience and testing which is secret, significant and useful. So to qualify as confidential, the information must also be imparted in circumstances which show there is an obligation of confidence. A classic situation would be that of information provided to a trusted advisor. The advisor is not then allowed to capitalise on the information for their own benefit. For example, in the recent case of CF Partners against Barclays, CF Partners were originally looking to obtain a loan from the bank to acquire a particular company. The bank acquired information from CF Partners over the course of the negotiations, which then fell through. Barclays then bought the target company and made a big profit selling it on. The bank hadn't signed a confidentiality agreement with CF Partners directly, but had signed one with its third-party intermediary. The court found that in the circumstances where the information had been supplied to Barclays for the purpose of evaluating CF Partners' acquisition, the bank's subsequent benefit from that information to buy the company amounted to a misuse of the information.
And it's also worth noting that if the recipient of confidential information discloses information to a third party and the third party is aware that it's confidential, then an action for breach of confidence can also be brought against that third party if it becomes necessary. The test that's applied by the court is to look at the reasonable man and to ask if such a person standing in the shoes of the recipient of the information would have realised upon reasonable grounds that the information was being given to him in confidence. The relationship between the person giving the information and the recipient may also create an obligation of confidentiality. For example, employees are duty-bound to keep their employer's secrets. However, the best way of protecting confidential information is not to rely on a duty being inferred, and instead to make the duty explicit by either a standalone confidentiality agreement or a confidentiality clause within a contract before disclosing any information. We'll go on to look at some examples of contracts where this is particularly relevant in a moment, but first a word on the confidential information relating to trade secrets. Trade secrets are the confidential information that's kept by a business that give it an edge over its competitors. In the UK, the definition of a trade secret has been developed through case law, but can often be difficult to draw the line between information that's commercially sensitive in a more general sense and information that can be protected as a trade secret. The law covers information which is secret in the sense that it's not generally known among or readily accessible to people within circles that normally deal with the information in question, has a commercial value stemming from the fact that it's a secret, and it's subject to reasonable steps by the holder of information to keep it secret. For example, you may have heard the story of Iron Brew with its secret recipe known only to 3 people who apparently never travel on the same plane, just in case. The EU Directive on Trade Secrets is also to be implemented by the end of 2018, and it seeks to harmonise the approach that's taken by EU member states in protecting trade secrets and specifying what remedies should be available to a trade secret holder to protect the trade secret. Whatever the impact of Brexit will have, the European Scrutiny Committee has expressed their view that no changes to UK law would be required to implement the directive, and so if you operate throughout Europe, the harmonisation of the definitions and remedies should make your life a little bit easier. One common question that's often asked is why the law of confidential information should be relied on, rather than using other intellectual property rights such as patents or copyright protection. There are several advantages to the laws of confidence which make it a valuable tool for a company. For example, in contrast to patents, designs or copyrights, the rights covered by confidential information aren't subject to a time limitation. Trade secrets and confidential information can subsist for as long as the business continues to trade and even beyond. In addition, applying for a patent results in publicity around your idea, which can lead to competitors learning from the patent or using and benefiting from it secretly despite the legal prohibitions. Copyright protects only copying of the information, and so it wouldn't, for example, protect an employee who's committed key customer details to memory and then approach the customers after the first employment period has ended. And this last example highlights how important confidentiality clauses are in employment contracts, and again we'll look at this in further detail later.
While many agreements contain provisions about confidentiality within them, it's also common to have separate agreements known as non-disclosure or simply confidentiality agreements. Typically, they will include a definition of the confidential information being protected, an obligation to keep the information secret and only use it for the permitted purpose, an outline of the circumstances in which and people to whom the other party is permitted to disclose the information, including where this is mandatory, for example by regulators, and what is to happen to information and records when no longer required. When defining confidential information, parties should consider whether this should include information disclosed orally, and if so, think about how this would be policed. For example, notes may be taken during meetings. The recipient will seek to reduce the scope of the confidentiality definition to exclude information that is in the public domain, either now or over the course of the agreement. Information that the recipient already lawfully knows, information received from a third party, and information disclosed on a non-confidential basis. Some of these exceptions are quite standard, but the disclosing party will need to think carefully about whether they are appropriate in every case. The disclosing party will often want to make the definition of confidential information as wide as possible, but as we discussed, merely labelling certain information as confidential will not make it so if it is not inherently confidential. A balancing act must be carried out, as if the definition is too wide, then it may not be upheld by the court, whereas if the definition is too narrow, then it may not catch the information that the parties would wish to protect. Having a written agreement avoids any doubts about whether the recipient of the information knew that it was confidential, and therefore makes it easier for a claim for breach of contract to be raised, or if the disclosing party suspects the recipient is about to breach the agreement, it could support an application for an interdict or injunction to stop them doing so. It also helps the disclosing party focus on what, when, how and to whom information needs to be disclosed, and to put in place procedures to secure the information. But the non-disclosure agreement is not a silver bullet, and its limitations should be borne in mind. We will look at this in further detail in our third webinar in this series, which will focus on preventing misuse of confidential information. But in brief, there are some issues with potential remedies for a breach of confidentiality obligation. Firstly, the main remedy for a breach of a non-disclosure agreement is an injunction, called an interdict in Scotland, to prevent release of the confidential information. However, this relies on the disclosing party knowing that the recipient is about to breach the agreement in advance of it taking place. Once the breach has happened and the information is out there, there is no legal remedy to restore its secrecy. In any event, injunctions are only granted at the court's discretion based on what is just and convenient and if proportionate to the misuse that has occurred or is going to occur. In terms of compensation, it may be possible to seek damages or an account of profits if the recipient has made use of the information, but accurately quantifying the damages can be quite difficult, especially where the value of the information lies more in its potential future value rather than its current value. The court has taken different approaches to awards of damages in the past and may assess them on the basis of what the party would have paid for the opportunity to be released from its obligation not to disclose the information, i.e. the hypothetical negotiation basis, or else may assess the damages on the basis of a loss of chance. Even if the recipient of the information acts in the utmost good faith, there will be some information that will inevitably subconsciously influence their actions.
One common place to find standalone non-disclosure agreements is in the context of acquisitions or joint ventures, when they're signed at an early stage in negotiations. Typically, the agreements in this context will cover the fact that there is a potential sale or joint venture being negotiated, things like the existence of the confidentiality agreement itself and its terms, and any detailed information that's going to be disclosed during the negotiations in connection with the potential sale or joint venture. In an acquisition context, buyers will want to prevent fishing expeditions where competitors are not actually interested in acquiring the company, but just want to profit from the detailed knowledge of its practices and processes. And these agreements are a way to protect anyone who has started negotiations to buy the company from using that information for their own commercial gain. For joint ventures, the particular terms are likely to depend on whether both parties are disclosing information about the businesses to be contributed to the joint venture, or whether one party is disclosing information about a business to be contributed to the joint venture and the other party is disclosing information about, for example, intellectual property rights to be licensed to the joint venture. One other point to bear in mind is in this context is when the obligations of confidentiality will expire, and if they're intended to continue after the joint venture comes to an end or is taken over by one of the parties.
Not all of the information that employees acquire in the course of their employment will be confidential, but it is important to ensure that, to the extent that it is, employees are made aware of their duty to keep it secret. Common law duties of confidentiality are relevant here, as we discussed earlier, if information which is not publicly available is given in circumstances which show an obligation of confidence, a duty of confidentiality will arise. This applies to the employment relationship as much as to a relationship between someone and their trusted advisor. As we will want to talk about, there are particular classes of confidential information which the courts have held are implied into every employment relationship. However, over and above these common law duties of confidentiality, most employment contracts contain a clause spelling out the details of the employee's duty to keep confidential information secret. If we consider first what is contained within the implied duty of confidentiality during employment, the leading case in this area is Facenda Chicken Limited against Fowler. Facenda bred, slaughtered and sold chickens and employed Mr. Fowler as its sales manager. Mr. Fowler resigned when he was arrested and charged with the theft of 45 cases of chickens, although he was subsequently acquitted of all theft charges. The next year, he set up his own business, competing with Facenda and recruiting former colleagues. The defendant claimed that Mr Fowler and his colleagues had breached their contract of employment by using confidential sales information relating to the requirements of customers and the prices they paid. As the employees had not signed contracts with express confidentiality restrictions, the High Court had to consider whether the restrictions should be implied into their contracts, and if so, whether they had breached them. Ultimately, it was found that there had been no breach, as the information in question fell short of being categorised as a trade secret. When considering the claim, the judge placed information available to employees into three categories. First, there is the trivia of the business, which is not at all confidential, including all information which is available to the public, either generally or on demand, as well as custom and practice in the trade. For example, a published patent specification well known to people in the industry concerned has been described as falling into this category. Secondly, there's information which has some confidential elements, which an employee can be obliged to keep confidential during their employment, but not for an unlimited period after the employment ends. This has been described as information that employees must keep confidential, but which, once learned, necessarily becomes part of their skill and knowledge applied in the course of business. Without express restrictions, however, on termination of the employee's employment, then the law allows him to use his full skill and knowledge for his own benefit in competition with his former employer. So, thirdly, there are truly confidential trade secrets which may be capable of remaining confidential indefinitely. In drawing these distinctions, the judge stated that the category into which particular information falls may depend on the nature of the industry, the nature of the information, whether the employer impressed the confidentiality of the information on the employee, and whether the confidential information can be easily isolated from other information which the employee is free to use or disclose.
It's also fair to say that there's been some blurring of the lines between the categories. For example, in the case of an employee carrying away a card index system that contained contact details for 325 of the employer's business contacts, it was found that this was not a trade secret, but it was nevertheless confidential information that the employee could only use to the extent that it was carried away in his head. As there was so much information in this case, it was clear that he could not have used the whole index without having deliberately memorised or copied it, and so this was a breach of his duty of confidentiality. In assessing the circumstances, the courts will also look at whether the information can properly be said to be the property of the employer, or whether it's actually the employee's own skill, experience, know-how and general knowledge which they can use without restraint. In this context, there's a difference between an ex-employee who makes use of knowledge that's recalled from years of experience in a particular job, which will normally form part of their own knowledge, and information that's specifically committed to memory, which will usually belong to their employer. For example, an employee might have encountered problems in a particular process in his previous job and have been party to the solutions that the company developed to solve it. If the same issue reoccurs in a subsequent job, the knowledge of what can be done to fix it is too vague to count as a trade secret, and so is found to be the employee's skills, knowledge and experience and general know-how gained throughout their employment. Due to this grey area between confidentiality and trade secrets, there's an implied duty of confidentiality for employers, and they're wise to attempt to properly specify in the employment contract that particular defined and sensitive information is confidential to the point of being a trade secret, that its disclosure is forbidden, and that the employer will be entitled to seek damages or injunctive relief if the employee discloses it. When drafting employment contracts, care must be taken to ensure that the definition of confidential information is not so wide that it attempts to include information which is inherently not able to be protected, running the risk that a court would not uphold it in any proceedings. And as with any type of confidentiality agreement or clause, you need to consider where the information came from, its purpose, and the damage it could do to the owner if it was disclosed without authorisation.
It's also worth noting at this stage that if an unauthorised disclosure of confidential information goes to the root of the employment contract, the employer may be entitled to dismiss the employee summarily, that is, without notice, provided it's reasonable to do so in all the circumstances. If, however, this breach is not fundamental to the employment contract, then the employee might argue that the dismissal itself was in breach of contract, i.e. it was a wrongful dismissal, freeing them from any express contractual restrictive covenants. And that can be a real worry. If the employer has been found to have breached the employment contract, then that then allows the employee to say that any post-termination restrictions are no longer binding. So it's one to watch out for. The employee may also be able to argue that a dismissal was an unfair dismissal, so a statutory unfair dismissal not really connected to the contract. So in those circumstances, it's always important to ensure that a fair procedure has been followed in any dismissal to minimise the risk of a claim proceeding and indeed being successful. After the termination of employment, although in theory information classed as a trade secret continues to be protected by the employee's implied duty of confidentiality, it is usual for concerned employers to impose express obligations in the employment contract to clarify for the court that the information is properly a trade secret and to emphasise to the employee the confidentiality obligation. The more precisely these clauses are drafted, the more likely it is that they will be respected by the employee and, if it comes to it, upheld by the court. So it's worth spelling out in the contract that the information specified is classed as a trade secret and that the information is important to the employer and that this is why it has taken steps to expressly protect its information, and that damages may not be an adequate remedy, and so the employer will be entitled to seek injunction or interdict. The courts have been more wary of imposing a continuing obligation of non-disclosure of confidential information as opposed to trade secrets following the termination of employment. In general, if the employer can demonstrate a proprietary interest and has attempted to protect the information expressly, then it is likely that this will be upheld. And if inadequate contractual provisions have been made in the employment contract to protect the confidential information, then another agreement might be appropriate, and that would be a settlement agreement, previously known as a compromise agreement. Before we go on to talk about settlement agreements, however, I wanted to highlight the particular position of company directors. By reason of their directorship, they have a continuing equitable duty of confidentiality. This means that they must use or disclose the company's confidential information only for the benefit of the company. In addition, similarly to an employee's employment contract, there will also normally be express confidentiality provisions contained within their service agreement.
Settlement agreements are, of course, not only used in the employment setting, but they are an example of where steps often need to be taken to protect confidential information. To continue with the employment example, they will often usually contain clauses providing that the employee has to return all of the employer's property, including confidential information and documents relating to its business. The confidentiality clause will also stipulate that the employee must not make copies of, use or disclose any confidential information except for any such information which is in or already comes into the public domain. As well as dealing with confidential information belonging to the employer, another clause usually provides that the agreement itself and its terms will be kept confidential. In the context of litigation settlement agreements, often confidentiality clauses prevent the parties from disclosing the terms of settlement beyond what is required for accounting purposes or other statutory obligations, and this means that a party can make an offer to settle without the fear of that offer appearing to be an admission of guilt. One other tax point to consider is that sometimes confidentiality obligations in settlement agreements can require the parties both to keep the information confidential, in which case there's no issue, but if only the employee is bound to keep it confidential, then in the past HMRC has argued that income tax should be paid on the consideration for keeping it confidential. Finally, whistleblowing legislation under the Public Interest Disclosure Act 1998 must also be borne in mind when drafting confidentiality clauses, particularly in settlement agreements but also in employment contracts. The legislation provides protection for workers reporting malpractices by their employers or third parties against victimisation or dismissal. For this to apply, the worker must have a reasonable belief that the information they are disclosing shows a relevant failure and also have a reasonable belief that the disclosure is in the public interest. The disclosure will then be protected depending on the identity of the person to whom it's made, with the primary method being disclosure to employers, and if not, then responsible third parties or prescribed persons. For civil service organisations, government departments and related arm's length bodies, specific guidance has been issued which stipulates that confidentiality clauses should only be included in settlement agreements where necessary and not as a matter of course. They also need to ensure that they do not deter staff from raising concerns with a regulatory or other statutory body about wrongdoing or poor practice in the department. This guidance does not, however, cover other public sector organisations such as the NHS, police or universities.
So now to consider some common drafting issues. Firstly, ensure that the definition of confidential information is adequate. It needs to be broad enough to cover any deliberate or accidental disclosure of information to the recipient, as well as any works derived from the confidential information. The recipient will, conversely, often want to restrict the definition as much as possible. Next, set down clearly that the recipient must keep the confidential information secret, and also explain what purposes they are allowed to use the information for. State in what circumstances the recipient is able to disclose the information. For example, they will commonly be allowed to disclose to their employees and advisors. Sometimes the party disclosing the information will try and make the recipients, employees and advisors sign separate confidentiality agreements in relation to the information. But this is generally felt to be a bit excessive, and it's sufficient that the recipient will be responsible for any breach of confidence by their employees and advisors. Make provisions for what should happen to the information if the project doesn't go ahead, which normally means it should be returned or destroyed. And finally, make sure you specify the duration of the agreement, taking into consideration how long the information will be valuable and confidential for.
The two main aspects to protecting confidential information under the law of confidence are to ensure that the information is only disclosed in circumstances where it's clear that the recipient has an obligation to keep it confidential, and to ensure that access to the information is restricted. It will normally be far easier to enforce a contractual obligation than to try and rely on the common law, and so thinking about potential issues in advance and entering into agreements accordingly is an important way of protecting your confidential information. We'll be looking in more detail about how to maintain what's called the necessary quality of confidence within the business in our next webinar in this series. But in brief, once you've documented the confidentiality obligations, there's some general practical steps that help you establish and maintain confidentiality. Some of them are listed on the slide, and they include restricting access to the confidential information and labelling information that's truly confidential as such, limiting access to areas where confidential processes take place, considering limiting early disclosure, keeping back information that's truly a trade secret until you've reached an advanced stage of negotiations and you're thinking about whether it's essential at all for it to be disclosed, advising employees how to keep information confidential, for example, not discussing company business in public areas and taking care when using laptops or tablets in public, and ensuring that there are appropriate IT policies and security protections in place, especially if your company operates a bring your own device scheme. This all might seem a bit obvious, but it's all part of demonstrating that you have the policies in place and that they are being enforced, which is helpful if the action needs to be taken in response to a breach. And finally, one other point is just remembering to keep audit logs and records so that you can show what projects each employee or consultant's been working on. That really concludes today's webinar, and what we'll do now is take any questions. As I mentioned at the beginning, you can put any questions in the chat box, and while you're doing that, I just take the opportunity to mention that there are also a number of other webinars in this series being run by Shepherd and Wedderburn at the moment, including on a property dispute resolution and construction law. If you'd like to find out any more about these or catch up on the previous webinars in these series, then the link's on the screen now. Doesn't look like we have any questions at the moment, so what we'll do is we will close the webinar there, but if you do have any questions, please just feel free to stick them in the chat box before you leave, and we will pick up with the questioner later. So thanks very much.
Thank you.